Well, we will learn in 8 weeks exactly how much time Derek Chauvin will spend in prison for George Floyd's murder.
Now the Department of Justice, as we just heard a few minutes ago, is launching an investigation into Minneapolis policing and practices. A lot to discuss here. Shan Wu is with us, defense attorney and former federal prosecutor Renato Mariotti joins us as well. Good morning to you both. Let's begin on the sentencing here, because the prosecution, Shan, believes there are a number of what they call aggravating factors, 5 key aggravating factors that they would like to see the judge apply here in 8 weeks when he does issue the sentence to lead to an even longer sentence for Chauvin. Will that happen?
I think there's a good chance of that, Poppy. I think that talk of the statutory maximum of 40 years is unlikely to happen. But I also think that, the defense made a calculation, a normal one, to put his fate, Chauvin's fate, in the hands of the judge rather than the jury, hoping that the judge will be more reasonable, more experienced, looking at the picture. But there are a lot of potential aggravating factors here, and I don't think you're going to see the the sentencing guidelines minimum 12.5 years. I think they are going to find some of these aggravating factors applied. The judge will agree with the prosecution. I think you're looking at something more in the range of 20 years.
Interesting. Renato Mariotti, Chauvin, of course, took the Fifth, did not take the stand during his trial. He will have an opportunity again to address the court during sentencing arguments. And I wonder, if you were his attorney, would you advise him to speak? And if so, what would you advise him to say?
So he's able to say anything during what's called the allocution, and I would advise him to express deep remorse. Mm-hmm. It's very important for the defendant in a case like this, and whenever I've given advice to defendants, when I represent them, it's always about trying to make sure that the judge understands that you're remorseful, that you take responsibility for your actions, that you understand the circumstances around it, you understand the deep pain that has been caused if there are victims. In this case, of course, there is. That's, I think, going to be the most important thing.
Well, Shan, one point that you made that I think is really interesting is that you think that this is really going to be a gloves-off moment for the prosecution when it comes to what they say at sentencing. Is that what do you expect?
Absolutely, Poppy. At the trial and in closing, the prosecutors have to be careful. In fact, I thought they walked right up to the line pushing for an emotional appeal to the jury. They have to be careful of that in trial. But at sentencing, the gloves are off. They can really express the outrage. They can actually cite to issues that are not so well supported by the evidence. They can ask the judge to draw inferences. It'll be much more emotional, I would expect. And, of course, you're also potentially going to hear from members of the Floyd family again. And this is not going to be constrained, by the jury's presence, the judge trying to make sure the jury doesn't hear too much emotion. This is directed to the judge, so that's why it's really going to be the gloves-off approach.
Renato, you served as a federal prosecutor. Now the Justice Department, just moments ago, announced a broader investigation into the Minneapolis Police Department, a pattern or practice investigation, alleging, in effect, or investigating whether it is true that there's a pattern here beyond George Floyd's killing and other killings we've seen of black men by police. Based on your experience and the evidence you've seen, do you see evidence of a pattern or practice here that's likely to lead to action?
Well, I think it's hard to tell just looking at it in a granular level. They really are going to be looking at data more broadly. I will say, given the experience of what happened here in Chicago, where we did have a similar pattern practice investigation, I do think there's a collaborative effort there. In other words, folks in Minneapolis, you saw actually testimony, of course, from folks in the force against the defendant in this case. I do think that there's going to be a collaborative element to this in which local authorities are going to say, we are willing to reform, and this actually can take the responsibility off of them, because they can then blame this investigation for the fact that they're going to need to do some reforms that are going to force them to do things that are actually going to make changes in the force that might be unpopular for officers.
Shan, the bar for appeal here, if there is an appeal, is got to be pretty high, right? I just wonder what the bar for appeal, wouldn't they have to get an appeal accepted? They would really have to show that there were some significant problems here in the process of the trial, no?
It is high, Poppy. It's not a discretionary appeal whether to take it. They'll automatically look at it. And I think that there are some significant issues on appeal, primarily that issue of the carbon monoxide testing not having been disclosed. And as I said before, I think the prosecution walked up to the line in terms of their appeals to emotion during the argument, and probably Chauvin will argue that not sequestering the jury was damaging to him. I think that last one's very weak. There may be a little bit of play on the first two, but in any appeal, any error, they're always balancing it against the weight of the evidence, and the weight of the evidence here is very, very overwhelming.
Yeah.
Shan Wu, Renato Mariotti, are reminding us there are a lot of more steps to go on this. Thanks very much. Well, a teenage girl